The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte.
The Attorney General was at the International Criminal Court in The Hague to respond to the prosecution's allegation that the Kenyan government was unwilling to assist it in accessing President Uhuru Kenyatta's bank records.
Has the government of Kenya sought the consent of the relevant individuals, specifically in this case of Mr. Kenyatta?
No, for very good reason. The Republic of Kenya is a sovereign, autonomous, independent state. It was my duty to keep a clear, independent distance from the prosecution and from the defense, and to have a direct engagement with the court.
It was an issue that was never raised. If you go to paragraph 9E, the request concerns transactions by individuals or linked companies at foreign exchange institutions or money service bureaus since June 2007.
Is Mr. Kay really suggesting that we just wanted to know whether Mr. Kenyatta did have some bank accounts and that we wouldn't then be interested in knowing what the records were? That's not, respectfully, a sensible proposition.
The prosecution has been changing its narrative continuously throughout this case. And the Kenya government merely became a bogeyman in this case very, very recently. That was never the narrative.
This, according to the Attorney General, was not the only request that the prosecution had made that was not within the government's purview.
I have said to them, who are your witnesses if you want me and the Republic of Kenya to protect them? The answer, Your Honors, may shock you. The answer has been, we cannot tell you the names of the witnesses because they are not safe with you.
You didn't seek the consent of Mr. Kenyatta because you are prohibited by Kenyan law to seek the consent, or you are not obligated by Kenyan law to seek the consent?
In theory, it is expected that the Central Bank of Kenya would have access to information or would have the authority to require information from banks. But banks themselves, in responding to the central bank, would have to comply with the Banking Act.
How long from the issuance of such order it would take?
It is not a process that can be assumed would take a week or 2 weeks or a month or 6 months or a year. It would be an indefinite process because of the independence of the institutions that we have talked about.
Githu claims he duly informed the prosecutor that her request required a judicial consent, but ever since there has been no progress on the matter.
The prosecutor stated her position, I stated mine. She stated she was entitled to the records, I stated that she wasn't. I encouraged her to take up the matter at an independent forum. She didn't. I considered myself then, as I do now, entitled to assume that the prosecutor was no longer interested in this particular disputed area of cooperation.
Couldn't you have seized the chamber before this timing, at a little bit earlier stage?
Back now, with hindsight, perhaps it would have been better if we had. But Your Honours will see from the correspondence, indeed in a rather tantalizing fashion, when its feet were held to the fire, when it was actually required to address the financial and telephone records which we're talking of, its frequent response was, if I can use the colloquial, the check's in the post. We're working on it.
The prosecution team claims it made this request 22 months ago. The government says it has received 40 requests from the ICC prosecutor and has since complied with 36 of them. Sylvia Chebet, Citizen Live at 9.